Hello, everyone, and welcome to our follow-up live immigration webinar. My name is Lynn McKenzie, and I am the immigration lead here at Relocation Africa. I'm here today with Tracy du Plessis, who is our South African immigration law specialist. Now, this webinar is being recorded, and a link to the replay will be shared with all the registrants later this week. Although your microphones will be muted during the session, please feel free during this Q&A style session to drop us your questions as we encourage active participation from you all. Now, our talk today is a follow-up from our very first live webinar where we covered the South African immigration law landscape with respect to policies and procedures which surround the adjudication of various work-related visas in South Africa. So today we'll be addressing some frequently asked questions, case studies, examples, and some of the anticipated changes sought to occur in South Africa's immigration law system in 2020. More information on all these topics may be obtained by reaching out to us via marketing@relocationafrica.com. We will then determine how we can best serve you all with regards to the immigration services which Relocation Africa offers. Now, with all those formalities out of the way, let us dive right in. Hi, Tracy, how are you doing?
Hi, good afternoon. I'm well, thank you, and happy to be here.
Thank you so much for being here with us today and for sharing your years of South African immigration law experience. We covered the various work visas in our last session. So one of them was the critical skills visa. So I really want to start us off with the critical skills visa. So in our last webinar, we covered the requirements for critical skills visas, and we addressed the various requirements, namely the educational qualifications and the various bodies where applicants must register. Now, how would you approach a critical skills work visa application in an instance where an applicant does not have a specific educational qualification, but has the relevant experience related to a particular skill?
Lynn, in terms of the South African Immigration Act, one may apply for a critical skills work visa if one possesses relevant educational qualifications or skills. I highlight the word or. However, in practice, the Department of Home Affairs ignores the word or, and they usually insist that the applicant does have the relevant qualification as well as experience. Therefore, I usually encourage applicants to apply only if they have the relevant qualifications and experience.
So does this mean that if you have experienced denials, or that you have experienced denials because of this disregard of the or written in the act, or is it your advice that you just don't even want to open that door to the possibility of even having a denial?
Unfortunately, with the Department of Home Affairs, there's no consistency. So what they do today and what they do tomorrow is something totally different. And there might be an adjudicator who recognizes the word or and would approve it. But as I said, it's very difficult to determine. So I won't say that I would not entertain such an application, but I would encourage the person to rather apply if they have both, or alternatively, first submit a waiver application requesting that the educational qualification be waived.
I see. So with regards to the critical skills requirements again, now there are always questions surrounding critical skills, quote unquote, extensions and the circumstances surrounding that notion. So that brings me to this following question. So if an applicant obtains their first critical skills work visa that's valid for 12 months, which they receive without an offer of employment because they don't require that in order to get that first 12 months, from my understanding. And they find themselves within those 12 months not being able to get a job. So, for example, they could be someone who fell seriously ill or were incapacitated for a few months or had other exigent circumstances. Would they be able to extend under those circumstances? If so, what are their options? And have you ever experienced something like this before?
Okay, so in terms of the Immigration Act, if one applies for a critical skills work visa and at the same time has an offer of employment, they may be granted a critical skills work visa for up to 5 years. However, if they apply without an offer, those are the instances where the initial work visa would be granted for 12 months, and within that 12 months, they must extend and provide the offer. So if there are special circumstances, in terms of the Immigration Act, the Act is silent with regards to that. So I would then still recommend that the applicant applies for the extension, but includes a detailed explanation relating to the special circumstances. At the end of the day, the Department of Home Affairs would have to make a decision based on the documentation presented to them. I've not had such a situation of this nature where the person has not had an offer of employment when the time comes to extend. And as I said, the Act is silent in this regard, so it's quite difficult to comment on whether or not such an application will be approved, but nothing prevents the applicant from submitting the application.
I see. Now, you mentioned that explanation. Now, is there sort of a template for that, or can they just write it in an affidavit form?
There's no specific template. My recommendation would be that they write it in the form of a detailed letter. It doesn't have to be an affidavit, but just a normal letter from them explaining the situations. And then the adjudicator would have to make a decision based on discretion. And I would recommend that the motivation be quite convincing.
Right, I'm sure. So speaking of the DHA, we had a recent meeting with the DHA Minister, Dr. Aaron Motsoaledi. I'm sure that you've met him or know of him, and to which Relocation Africa was graciously invited to participate, as well as we were asked to represent the British Chamber of Business in that roundtable discussion. The minister expressed that the new critical skills list would be submitted by the Department of Higher Education to the DHA for review in March of 2020. Now, in response, some of the participants claim that although this new list had not been implemented, applicants are receiving rejections because adjudicators are adjudicating applications based on this new list. Do you agree with this in this case? And are you seeing the trends in this regard? If so, can you provide us an example?
What I have experienced is that the Department of Home Affairs is rejecting certain applications that are currently still on the list, but not saying we reject it because it's not on the new list, but finding other reasons to reject. For example, the corporate general manager category is currently on the list and applications of that nature should be adjudicated accordingly. However, the Department of Home Affairs has a tendency of finding reasons to reject. For example, they'll say that the person does not form part of the board of directors of the company, or the company where the applicant is working is not a corporate company, or the applicant is not on a CEO level, etc. So in essence, they're rejecting in error, and one could be challenged in court, or the Department of Home Affairs could be challenged in court if an applicant is willing to take that a step further. So that is the tendency that I found, that they are not saying we reject it because it's not on the list, but they are looking for other reasons to reject those applications.
I see. So in light of what you just mentioned, then what are your overall thoughts on the critical skills work visa application?
What I found is the challenges we face is that in order to apply for a critical skills work visa, there are two steps that must be followed prior or leading up to that application. One is to have one's foreign qualifications evaluated by SAQA. One of the challenges there is that SAQA, which is the South African Qualifications Authority, often reaches out to the educational institution outside South Africa to verify the authenticity of the applicant's qualifications. And if that educational qualification does not revert back to SAQA, SAQA is then unable to finalize the evaluation process. That in itself can be a hurdle for the person to apply for the critical skills work visa. The second part and the SAQA takes about a month. The second part of the process is that after you have the SAQA evaluation, one has to register with the relevant board, body or council in South Africa as part of the requirements for the work visa. And sometimes that is a challenge because there are certain boards, bodies or councils where they refuse to accept applicants as members for various reasons, because the applicant cannot meet the requirements. For example, if an applicant is applying for a critical skills work visa under the engineering category, they have to register with the Engineering Council of South Africa. And the Engineering Council requests projects and assignments from the applicant and letters from the supervisors from when the applicant first studied, which could in essence be 20 or 30 years ago. And these applicants don't always have access to that information. The Engineering Council also wants the applicant to provide 2 referral letters from existing engineering council members. And if you're a foreign national, you don't necessarily know anybody that is a member of an engineering council. So these are the types of challenges that one faces. And then the engineering council often takes 12 months to process an application. They call you in for an interview and they ask questions that is very difficult to answer. And at the end of the day, they sometimes come back and say, we don't recommend it, or we cannot accept you as a member, after waiting 12 months and jumping through all their hurdles.
Well, that does sound quite exhaustive and quite a burden on the applicant that's already going through a difficult process. So therefore, do you think that these relative bodies are just creating an undue burden on applicants to assure that they do not pursue these types of visas?
In my opinion, the Department of Home Affairs did not do proper consultations with these bodies and do sufficient research prior to implementing the requirement for applicants to register.
I see. So in hindsight, they did not do their due diligence to assure efficiency in that regard. So do you think that the DHA can do more to assure a more efficient process by SAQA and the other registration bodies?
With regards to SAQA, I don't think so, because the fact that SAQA wants to verify the authenticity of educational qualification is actually a good thing, and they can't be held accountable if the educational institution outside South Africa does not reply to them. I think that perhaps the department could engage more with the relevant board bodies or councils to alleviate some of the challenges.
I see. So there seems to be a gap, again, making it quite burdensome on the applicant to assure approval. They have to sort of tick all the relevant boxes and are really at the mercy of these bodies. So during the meeting, the DHA also claimed that the turnaround times for critical skills visas is 6 to 8 weeks. Is that your experience?
This usually depends on where one applies. If a person applies for the critical skills work visa in South Africa, generally it takes 8 to 12 weeks to be processed. Sometimes some applications fall through the cracks and take longer. If a person applies at an embassy or mission outside South Africa, it generally takes 4 to 8 weeks plus to be processed. But there are certain countries where the processing times are very challenging. For example, in Zimbabwe, people are waiting more than 6 months for any visa category to be processed.
But that's just for the applications itself, right? So because you mentioned before that they have to do the critical skills and the registration and the evaluations by SAQA, so that would actually extend the entire process, right?
That's correct. So if we're looking at the critical skills work visa application, they first have to do the SAQA evaluation. That in essence takes a minimum of about 1 month. Then they must do the registration with the relevant board body or council, which could take a minimum of 1 month, maybe 2 months if it isn't a challenging process. So you're looking at possibly 3 months later that the applicant is then in a position to apply for the actual critical skills work visa, which then takes 6, 8 or 12 weeks plus.
Thank you. That you cleared that up really well. So further to that point, let me ask you then, if you were an adjudicator, how would you assess a critical skills work visa application?
Lynn, I would adhere strictly to the South African Immigration Act and regulations to ensure that the applicant complies with everything as prescribed in the Act and regulations. I would not steer from that.
Even if there was no room for discretion on a case-by-case basis, how would you handle that kind of situation?
I actually don't favor applications being adjudicated based on discretion, because the minute that you open that door and allow applications to be processed based on discretion, that is when you open the door to erroneous decisions being made, because then you're not following exactly in line with the law. And in essence, you are not doing the correct thing. This really leads to erroneous decisions. And as I said, I would personally steer away from leaving room for discretion. I'd really, really prefer to stick entirely to the law.
Great. So connecting to the critical skills work visa, I understand that via the critical skills route, a person can actually apply for permanent residence. Is that right? And what's the process, and can they actually apply for critical skills and permanent residence at the same time?
Nothing prevents a person from applying simultaneously. However, I always recommend that my clients first obtain the critical skills work visa and thereafter apply for permanent residence. And the documentation for permanent residence would be pretty much the same as what one would require for the work visa. There are one or two additional documents like birth certificates, photographs in a different form, etc. And once a person has applied for permanent residence, it could take anything from 6 months to several years to be processed, during which time it's imperative that the applicant ensures that their work visa remains valid at all times.
You said years. Now, what would you attest such a long processing time to? Because I would have assumed a faster processing time as it's linked to a very high-skilled work visa. Do people really assume that they would automatically have a faster processing time because they possess the critical skills already? Is that your experience?
The processing times or the length of time that they take to process is, I would assume, a result of staff shortages, lack of knowledge, and a number of other internal aspects. But yes, people do generally assume that if they apply under critical skills, the applications will be processed quicker. We have found that because of the inconsistencies, one person's will take 6 months, another one's will take 3 years, and often along the way, the assumption is that maybe the immigration practitioner who assisted did something wrong, but usually it's just luck of the draw. It depends which adjudicator the application lands on.
Well, I really hope that this year brings some significant improvement with regards to the processing of critical skills visas. But with that, let's move on to the ICT, the Intercompany Transfer Work Visas. Now, we previously expressed to our participants in the last webinar that a crucial requirement for an ICT work visa is the skills transfer plan. Can you briefly describe what should be included in the STP and whether there's anything in particular that the DHA looks for in this plan?
Then there are no particular guidelines provided by the Department of Home Affairs for this plan. I'm of the opinion that they don't really look at anything in particular. However, I always advise clients to ensure that the plan includes the full names and job title of the work visa applicant, the full names, job title, and South African identity number of the local employee to whom the skills are going to be transferred, the specific skills which will be transferred, and the time schedule for transferring the skills. The plan should also include things like objectives, expected outcomes, etc.
So are there any reporting or auditing requirements for the DHA to ensure that companies are actually adhering to what they put into that STP, or are they not that strict in that regard?
Once again, there's nothing prescribed in the Act and regulations regarding skills transfer plan reporting and auditing. And to date, I haven't really heard of any companies that have been audited in that regard.
I see. With regards to the maximum duration of validity, ICTs are issued for a maximum of 4 years, is that correct? And may not be extended beyond those 4 years. Are there any circumstances, maybe special circumstances, which would allow an applicant to extend their work visa?
One may apply for a waiver, which is a formal application submitted to the Department of Home Affairs, whereby requesting permission to be allowed to extend the 4-year intra-company transfer work visa from within South Africa. But my experience has been that these waivers are rarely approved. However, the applicant may return to their usual country of residence and apply for a new intra-company transfer work visa, at which point I recommend that they include a detailed explanation as to why they need to continue their assignment in South Africa. I further want to also elaborate on the fact that clients often get confused with extending a new visa. The minute you apply for a new visa outside South Africa, it is not seen as an extension. It is seen as a new application.
I see. So are there examples you've worked on in the past in light of that scenario? And would you agree that the ICT is actually one of the quote unquote easiest visas to attain in terms of process, efficiency, and percentage of approval?
At the present moment, the intra-company transfer work visa is the easiest application to apply for, and it is requests the least challenging a number of requirements. So yes, at this point in time, it is the easier one to apply for.
Thank you so much. Before we move along and continue our discussion, this is just a quick reminder to our audience that the chat box is open, so don't be shy and feel free to send us questions or comments, and we'll address them accordingly. So let's now talk about general work visas. Now, in our last webinar, we previously discussed the challenges with obtaining a general work visa. And in the meeting that we had with the minister, some participants expressed that the general work visa rejections are at their highest in many years. Do you agree with that statement, Tracy? And if so, why do you think that's the case?
I think that in recent years, there have been very little general work visa applications submitted because one cannot meet the requirement, specifically the Department of Labour recommendation requirement. And in instances where they do apply, it is, yes, it is rejected more often than it was in the past. I am of the opinion that the main reason for rejection is a result of negative recommendations from the Department of Labour, because this is a crucial requirement when applying for a general work visa. And in most instances, the Department of Labour miraculously finds a local candidate to fill the position, which at the end of the day is actually not qualified to fulfill the position, but they say that they found somebody, and this results in visa applications being rejected.
They find somebody. How do they know? Do they do their own independent investigation, or in determining whether they are local candidates for the job? I mean, in hindsight, it seems that they are indirectly steering people away from even applying for this visa.
It does seem like they're steering people away. I mean, we're not really privy to what goes on behind closed doors at the Department of Labour, but according to what we've heard, the reason or how they find local candidates is by searching their own database and by engaging and reaching out to other recruitment agencies around them.
I see. So in light of that, do you think that the general work visa category should just be abolished?
Unless the specific Department of Labour recommendation requirements changes, it might as well be abolished. But there are rumours that the requirements may be changing in the future, and I guess we'll have to wait and see.
With the changes, do you anticipate a positive change? Can you elaborate further on your thoughts on that?
Unfortunately, at this point in time, we don't really know what the changes are and when they will be implemented, but we do anticipate that it will be positive.
Well, we can all be hopeful. Do you believe that the DHA should become more involved and encourage significant change within the Department of Labour, or do you think it'll be difficult to control at this point?
I do actually believe that intervention from the Department of Home Affairs would assist with alleviating the challenges experienced with obtaining recommendations from the Department of Labour.
That's interesting, because also in the meeting with the minister, it was mentioned that the DHA would actually be working closely with the Department of Labour and the Department of Trade and Industry to address the challenges that were posed by the participants in the discussion and immigration practitioners. So we are hoping that the minister will continue to engage with us on the ground in order to implement and interpret the law accordingly. So before we move on, I just want to touch on one more topic that was addressed at the DHA meeting, and that is the e-visa system. So recently they launched the e-visa system, which was successfully done by a Kenyan national. And so my question with regards to the e-visa, now it's limited to visitors' visas, I understand. And do you think that will threaten the practice of immigration law?
I don't think so. Even if applications may be submitted online, applicants would still require assistance with ensuring that they comply with all the requirements, that the online application form has been completed correctly, etc. So, it might just increase the need for immigration practitioners.
That's great. So we all will still be around then to assist our clients accordingly. That brings us to our question session. If anyone has any additional questions and or comments, please don't be shy to share them with us. We'll be happy to address them and address as many as possible. We'll give you all a minute or two, or a few seconds, I should say. Are you feeling pretty optimistic about how we're moving forward with regards to processing, just in general, from a corporate perspective?
I think so. I think the new minister is hands-on, and I think there are good changes ahead.
Yeah, no, it was very encouraging. It's really nice to see that governmental entities are working closely with us on the ground so that we're able to effectively work with them and in addition be able to service our clients in the best way that we can. So I'm not seeing any questions coming through, but always feel free to connect with us via our various social media platforms and join our community. But we really want to take this opportunity and thank you all so much for joining us today. And a special thank you to you, Tracy, for sharing your insight and your experience with us. We'll send you invitations for future webinars, and this webinar will be uploaded on our YouTube channel, and you'll receive a direct link to the recording. So please feel free to share with your colleagues. Should you have any colleagues who wish to join our mailing list, please contact marketing@relocationafrica.com. So I wish you all a great remainder of the week ahead. Ciao for now.